Ready? Exercise number 14, Series C, Legal Matter. Start. In the first instance, no material is produced before us to justify that aforesaid basis of the formula was adopted while issuing the notification. In the absence of any such material, it would be anybody's guess as to what went in the mind of the central government in issuing these notifications and prescribing the service tax to be calculated on a value which is equivalent to 33% of the gross amount. Secondly, the language itself demolishes the argument of the learned counsel for the revenue, as it says 33% of the gross amount charged from any person by such commercial concern for providing the said taxable service. Stop. Next para. According to these notifications, service tax is to be calculated on a value which is 33% of the gross amount that is charged from the service recipient. Obviously, no amount is charged under bracket and it could not be bracket out by the service provider in respect of goods or materials which are supplied by the service recipient. It also makes it clear that valuation of gross amount has a causal connection with the amount that is charged by the service provider, as that becomes the element of taxable service. Stop. Next para. Thirdly, even when the explanation was added why the notification dated March 1, 2005, it only explained that the gross amount charged shall include the value of goods and materials supplied for, provided, or used or by provider of construction service. Thus, though it took care of the value of goods and materials supplied by the service provider under bracket SSC, by including value of such goods and materials for the purpose of arriving at gross amount charged, it did not deal with any eventuality whereby value of goods and materials supplied or provided by the service recipient were also to be included in arriving at gross amount charged. Stop. Next para. A close look at the Finance Act 1994 would show that the fixed taxable services referred to in the charging section 65 under bracket 105 bracket out would refer only to service contracts simpliciter and not to composite works contracts. This is clear from the very language of section 65 under bracket 105 bracket out, which defines taxable service as any service provided. Further, while referring to exemption notifications, it observed. Stop. Next para. Since the levy itself of service tax has been found to be non-existent, no question of any exemption would arise. It is clear from the above that the service tax is to be levied in respect of taxable services and for the purpose of arriving at 33% of the gross amount charged, unless value of some goods/materials is specifically included by the legislature that cannot be added. Stop. Next para. It is to be borne in mind that the notifications in questions are exemption notifications which have been issued under section 93 of the Act. As per section 93, the central government is empowered to grant exemption from the levy of service tax either wholly or partly. which is leviable on any taxable service defined in any of subclauses of clause 105 of section 65. For the aforesaid reasons, we find ourselves in agreement with the view taken by the full bench of CESTAT in the impugned judgment dated September 6, 2013, and dismiss these appeals of the revenue. Stop. Thank you very much.